With LawPay, your firm's finances are ready for whatever comes next. Our trusted solution secures your payment process, speeds up collections, and ensures IOLTA compliance, while freeing your time for what really matters, your clients. DC Bar members, sign up and we'll waive your monthly fee for 3 months. Learn more at lawpay.com/DCBar.
Welcome to Brief Encounters. I'm Caroline Lannon, Program Attorney with the DC Bar's Communities Office. I'm joined today by Michael D. Ehrenstein, founder of the international business litigation boutique Ehrenstein Sager. Today we will be talking about remedies for international terrorism. Thank you for joining me today, Mike. Could you share a bit about your background and experience?
Sure. Well, first of all, thanks for having me on again. It's always a pleasure to appear on the DC Bar podcast, and I'm happy to tell you a little bit about my background. I've been an attorney for about 34 years now. I went to Middlebury College and went to University of Miami Law School. And then after that, I got into business litigation, stayed at a small firm in South Florida for about 17 years, and then decided I was interested in branching out on my own. Being from South Florida, there's so much international work that comes in and out of Miami. We are a touch point for South and Central America, as well as for Europe. And so you can't help but be involved in international law if you're an attorney in Miami. That fact helped develop a broader interest in international law for me. And I got more and more involved in some larger and larger cases over time. After I left my first firm and started another firm, my interest in international law grew, and I ended up having the privilege of being involved in some fairly chunky litigation representing the government of Angola in New York and in Washington, D.C. And because of that, I started to really get interested in the Foreign Sovereign Immunities Act.
So your location really brought you into international law. You mentioned Angola. What are some of the challenges that you faced in your career with this international law?
Well, I'm reminded of the first words of a book. The first words were, "Geography is my wound. It is also my port of call." And I think you could say a little bit the same about being a lawyer in South Florida. It is a fact that our geography dictates a lot about the types of practices that we engage in. South Florida is a tourism center, it's a transportation center, it's a healthcare center, it's a real estate growth center. So all of those industries drive our legal work. And as you can see, because we're such a destination, all of those industries have international components to them, which also drive our practice.
Driving it not just people in the United States to Florida, but as well across the world.
Across the world, absolutely. So the challenges that raises for somebody who's practicing here, especially for somebody who's embarrassingly monolinguistic, the challenges are language is always a barrier. Culture is a barrier. I have arbitrated fairly large cases for enterprises from the Caribbean or enterprises from South America who have a very different view of how the judicial process is supposed to work than how we do. And so part of the challenge that we have is to sort of translate, well, this is the way things are done here. And even though you're not used to that, that's something that you're going to have to get used to if we're going to be proceeding in this forum, in this venue.
That's definitely a fine line to toe because, again, you're in the US, this is what's going on, but you don't necessarily want that national exceptionalism that we do see.
No, you can't have that. I mean, you have to be able to explain to a foreign client who is litigating here or a foreign client who is arbitrating here that there are specific legal differences that they should be aware of. And in doing that, you have to be sensitive to the cultural perspective that they might have. And vice versa. If we're litigating here or arbitrating here for a local party against a foreign party, you might have to adjust the way that you're negotiating with that foreign party in order to be able to make your views and perspectives better understood through their legal and cultural prism.
Constantly adapting, basically.
Absolutely.
So before we jump into these two acts that we're going to discuss, I was wondering, would you mind talking about this landscape of diplomacy that we're seeing nowadays and then also before these two acts, so before 1976?
Well, before 1976, there was this sort of absolute recognition that a foreign state could not be sued in the United States in our courts. We recognized and afforded great respect to the sovereignty of other nations. And as a result of that, we would not allow our courts to impose our justice on a foreign nation. And that rule existed for very good reason. I mean, in a world in which even before the 70s, the world was one in which nations engaged with each other on executive and diplomatic levels that were important to preserve, and allowing a US justice system to impose judgments against foreign countries could have really bad effects on the relation of the countries to each other. That view started to deteriorate as countries started to engage in more and more commercial conduct. So, as countries engaged in more and more commercial conduct, they started getting into disagreements where, there's a two-party contract. One party is a US citizen, another party is a foreign country. And the contract gets breached by the foreign country. And the foreign country could say, I have sovereign immunity, leaving our local businessman, stuck with no
Exactly.
remedy at all.
Mm-hmm.
And so the State Department started to recognize that there was a difference between a state acting in its capacity as a state and a state acting in its capacity as a commercial actor. If the state is going to engage in a commercial process, I, as a state, am going to sell you 50 bales of grain. That's a commercial contract for which sovereign immunity maybe shouldn't really apply. And the State Department started to recognize that and started to restrict the application of sovereign immunity to only those instances in which the state is acting as a state, not where it's acting as a commercial player. And that was sort of codified in something called the Tate Letter. I think that was in the early 50s. And the Tate Letter, although it recognized this distinction between commercial and state, it left parties and courts in a little bit of a quandary because nobody was able to know in a particular case, is the sovereign immunity going to be available or not? Because a lot of it depended on what would the State Department say about it. So if there was a dispute between a party and a state, it would be brought into court and the court would wait for the State Department to weigh in and say, well, sovereign immunity should exist here, or no, it shouldn't exist there. And that lent itself to a lot of inconsistencies and a lot of maybe a little gamesmanship where, I have a better relationship with so-and-so at the State Department and I can get a waiver, or no, I can't. So in order to redress the inconsistencies that were created by the State Department, the executive determining when and how sovereign immunity should apply in the commercial context, Congress enacted the Foreign Sovereign Immunities Act. And that was, I think, in 1976. So when Congress enacted the Foreign Sovereign Immunities Act, Congress said, we're starting with the principle that no matter what, foreign sovereigns are immune. Nobody can sue a foreign sovereign government in the United States courts. And then the statute went on to list a number of different exceptions. Okay. And those exceptions, some of which really made a lot of sense, just instinctively, and some of which have created enormous volumes of case law because it just wasn't that clear what was intended. I'll give you an example of when an exception applied. An exception to foreign sovereign immunity applied is if the country that you're suing has explicitly waived its right to foreign sovereign immunity. Such an explicit waiver can occur in the terms of a contract itself. It can occur pursuant to the terms of a treaty. And so where you have an explicit waiver, it's very clear and easy to figure out. There's also an implicit waiver, which is acceptable, but that lends itself to more confusion and, of course, more litigation and more smart lawyers arguing on both sides of the issue.
As anything that's implicit always does.
Right, exactly. So then there's the commercial activities exception. That exception is also an exception which has created an enormous amount of litigation because it was susceptible to more than one interpretation on a number of different levels. But the general rule established by that exception is that if the foreign entity carried on a commercial activity in the United States or performed an act in the United States in connection with commercial activity outside of the United States, or did an act in connection with commercial activity outside the United States, which caused a direct effect in the United States, then the exception could apply. So you can see just by the tongue twisting way in which I tried to articulate that, how much room there is there for disagreements. Another exception, which I think is important, is the property taken in violation of international law exception. So when a country seizes or expropriates property from a private individual and doesn't, within a reasonable period of time, pay a fair price for it, that is actionable in the United States.
And I think we've seen that with the Holocaust, with artwork, correct?
Absolutely. Absolutely. So that is one of the big areas in which that litigation falls under in the Foreign Sovereign Immunities Act litigation. Holocaust art recovery claims made by victims of the Holocaust for the expropriation of their property by Nazis and, the German government or the Austrian government, as it may be, or others. There have been others. But for our purposes today, I think the exception that is of greatest interest is the exception that is established for claims that are made against state sponsors of terrorism that have harmed U.S. nationals. Under that exception, a foreign state that has been designated by our State Department as a state sponsor of terrorism can be held accountable for money damages for any act of torture, extrajudicial killing, aircraft sabotage, hostage taking, or the provision of material support or resources for that kind of a terrorist act. And in those cases, the country itself can be held accountable.
Interesting. So I know too, with the state-sponsored actors, we see it with torture, terrorism. I think we've also seen it with financial institutions as well, basically masking in the past, correct?
Yes, so that's a different twist on a similar claim. So the Foreign Sovereign Immunities Act exists to establish the scope of immunity of foreign countries. In this case, we're talking about the absence of immunity for a state sponsor of terrorism. So if the State Department has designated a country like, for example, Iran, has been designated as a state sponsor of terrorism since I think the early 80s. If that designated country engages in an act of terrorism or supports an act of terrorism, that country can be held accountable for money damages for the harm caused to U.S. nationals by the incident.
And so you did mention torture as well, and I know we're going to discuss the TVPA, the Torture Victim Protection Act, but do you mind defining torture in this context?
There's a statutory definition. It's not surprising, okay? Torture is defined in general terms to include any act which is specifically intended to inflict severe physical or mental pain or suffering. If you're a fan of violent movies, you can imagine what that includes. Anything from, breaking bones, sleep deprivation, ripping out fingernails, cutting, stabbing, and any of that kind of stuff, severe physical or mental pain is actionable as torture.
We do have mental suffering, though, there as well. So we could possibly have torture that isn't physical.
Absolutely. So to get back to your question, though, about financial institution liability, and I said that's a little bit of a different twist. So FSIA, The Foreign Sovereign Immunities Act focuses on the liability or the limitation of scope of liability of foreign countries. A lot of times, designated terrorist organizations engage in terroristic activity that is financed from somewhere. And so financial institutions get sucked into the scope of liability, but it's not under the Foreign Sovereign Immunities Act. It's under the Justice Against Sponsors of Terrorism Act, JASTA. It was enacted in, I think, 2015 or 16. And what JASTA says is that anybody who's engaged in terroristic activity, if they're supported in a material way by somebody else along the way, that somebody else can have exposure for the same type of civil liability. In order for exposure to exist under JASTA, for, say, for example, a bank, the terrorist that was aided by the defendant has to have committed an act of international terrorism that injured a plaintiff. The defendant must have been generally aware. It doesn't have to have been specifically aware, but it has to have been generally aware that it was assuming a role in the party's terrorist activities at the time that it provided assistance. And third, it must have knowingly and substantially assisted the act of terrorism that injured the plaintiff. So they had to know about the specific act, and they had to knowingly and substantially have assisted in that specific act. And that's where most of those cases get tripped up. There are plenty of cases where victims of terrorism that have been perpetrated by designated foreign terrorist organizations, but not state sponsors. For example, Islamic Jihad. It's not a state actor. It's supported by certain states, or Hamas. It's supported by a certain state, but it's not a state actor. But it is a foreign designated terrorist organization. Now, when that designated terrorist organization receives financing through a bank, that bank, in theory, can be held accountable if it meets those three criteria: that the defendant was injured, that the bank knew, or that it was generally aware that it was supporting terrorist activities, and it knew specifically that it was assisting the specific act of terrorism that harmed the plaintiff. That third element is where most of these cases die.
I was going to say that has to be extremely hard to prove.
Very, very, very hard to prove. In fact, in looking at this, I've reviewed maybe 24 cases where the elements usually can't be pled, but sometimes even if they get pled, they can't get enough evidence to support it so that summary judgment ends up getting entered.
I mean, are they looking for, a note on the loan application and saying, I would like this money to assist?
That would be great. Or if they could have, an eyewitness testifying, I was at the bank, I had the conversation with the client and with the bank officer where they specifically talked about how they needed to have money to be able to get the fuel to launch this particular rocket that ended up hitting this particular civilian. That's almost an impossible standard, I think. Maybe there have been some successful cases out there. I haven't seen a lot of them.
Yeah, that is extremely hard to prove. So let's shift gears a little bit and move on to the Torture Victim Protection Act. Do you mind giving us a little bit of an overview on that as well and how it ties to the FSIA?
So there was originally an alien tort statute, which was maybe 2 sentences long, and it was from very early on in our history. And the alien tort statute basically said any alien who's been harmed as a result of a tort that has been committed here can bring an action here. That was supplemented more recently by the Torture Victim Protection Act. And basically what that act says is, while we definitely have carved away at the FSIA for permitting liability to exist in certain instances of terrorism, we have not recognized yet that our jurisdiction extends to acts of torture that have been perpetrated on foreign soil by foreign nationals against foreign people. So we are not, one of the concerns that Congress has always had under the FSIA and under the Alien Tort Statute is we are not the court of the world. It would be great if we could all wave a magic wand and say there is enough court space and time and money and availability to be able to provide justice to anyone who seeks it. We can't do that. And we're not really in a position to, we don't want to do that. But there are some things that are so foul and egregious that our Congress has now said, you know what? We will exercise jurisdiction in cases of torture. And unlike the Foreign Sovereign Immunities Act, in order to be a plaintiff for the terrorism exception under the Foreign Sovereign Immunities Act, you have to be, for all intents and purposes, a US national. Under the Alien Tort Statute, Torture Victim Protection Act, you don't have to be a US national. You can be a foreign national. Under the FSIA, the defendant can be the country. Under the TVPA, it cannot be the country. It has to be the individual. So that's really where the distinction lies between those two acts.
Can you discuss any significant amendments or modifications to FSIA and the TVPA that has been enacted within the past couple of years, especially since 9/11? I know you did mention JASTA already.
Yeah, JASTA was, I think, in 2016 or 15, and that sort of expanded the scope of liability against aiders and what I would just, loosely call aiders and abettors. The Foreign Sovereign Immunities Act has been modified or amended a bunch of times since its enactment in 1976, but most materially for our purposes, it was modified when the exception for terrorism was enacted. Those are really the two major modifications, and the adoption of the Torture Victim Protection Act also was a significant addition. It wasn't really a modification of FSIA, but it was a significant addition to the arsenal with which an injured plaintiff could pursue claims for terroristic or torture types of injuries.
So you did mention the idea that, the US isn't the core of the world, but we do have these pretty strong acts here. Are there any conflicts with international laws or treaties or other countries' laws that we're seeing, especially with this in regards to international torture?
That's a really broad question and hard to answer succinctly. There's always going to be conflict between the United States and its exercise of jurisdiction and those whom we've designated as foreign state sponsors of terror. So, I mean, if you look at the way these cases typically, cases against Iran, for example, there have been a number of cases against Iran for being a contributor to US nationals who have been harmed in attacks around the world. In those cases, Iran typically doesn't even appear and defend, right? Iran just defaults, assuming that they've been properly served, which is a whole nother twist under the Foreign Sovereign Immunities Act. But assuming they've been properly served, they typically default, and then liability is established. And Iran typically won't pay the judgment. You wouldn't expect them to just, write the check. So there has to be an effort made globally to find where their assets are and how we can collect from them. There's also something called the United States Victims of State-Sponsored Terrorism Fund, which was established by Congress in 2015 to help provide compensation to US nationals who've been injured in acts of international state-sponsored terrorism. And so that fund is funded through, among other things, assets that the United States has decided to seize, that the United States can seize from foreign sponsors of terror.
Interesting. So do other human rights organizations or international organizations like the UN play a role in this as well, in these cases?
Certainly, there are other jurisdictions which can afford a remedy. Every US national who's been harmed in a foreign terroristic incident is not required to bring his or her action here, although here may be the best place for that action to be heard. They can certainly bring the claims sometimes in the jurisdictions where the incidents occurred. So there are cases where US nationals have brought claims in Israel for injuries that have occurred or been suffered in Israel as a result of terroristic activity. Same thing, I think, in Argentina, and I'm sure other jurisdictions. As far as other international organizations, I'm not sure if any have the jurisdiction to consider claims against countries and award damages.
Very interesting. So, switching gears just a little bit, we mentioned state sponsored actors as well as non governmental organizations. Turning to recent events, like how could these laws possibly be applied? We have Hamas as well as Russia and Ukraine, and also other counterattacks that we're seeing on an international level.
So it's important to distinguish, at least in my mind, what Hamas's attack on Israel was as compared to Russia's attack on Ukraine. I am not an expert on, what qualifies as war versus what qualifies as terrorism, and if there's really any gray area in between them. But having said that, if there's even a spectrum where there's a country waging war on one end of the spectrum and a terroristic attack on the other end of the spectrum, the Hamas attack on Israel would certainly fall far on the far end of the spectrum as a terrorist attack. Now, I'm sure there are listeners who will disagree with me and say Hamas is just a group of freedom fighters, and I won't get into the fine points of that, except to say, even if they are, which I respectfully would disagree with, but even if they are, the conduct of the attack that occurred on October 7th was beyond the pale barbaric. And that would certainly qualify as terroristic under any definition. So there are remedies provided for that. Here, at least according to two lawsuits which have recently been filed, and according to the State Department, Hamas was supported, aided, and abetted in a major way by Iran. Iran funded the efforts of Hamas. Iran gave them money to build tunnels. Iran gave them money to build rockets, gave them technology, gave them training, was more than aware of what was going on, participated in meetings to sort of green light the attack. So all of that taken into consideration, under the Foreign Sovereign Immunities Act, Iran absolutely can be held accountable for the attack by Hamas because it had provided material support or resources which enabled Hamas to engage in that conduct. So there's two cases which have recently been filed, which kind of touch on both of the main issues we've talked about here. One is a case that was filed on January 31st of this year called Estate of Sassi versus the Republic of Iran. And it was filed by, I think it was Quinn Emanuel, and it's a 130-page complaint, which goes into great detail about the attack and where the support and money came from. And it seeks to hold Iran accountable for all of the losses and damages incurred by US nationals. The case involves, I think, 67 US nationals that are suing. And the second case, which was also filed on the same date, but was filed in the Southern District of New York, it's called Radan versus Binance and the Islamic Republic of Iran and Syrian Arab Republic. That case is interesting because, well, they're both interesting. The second case, Radan versus Binance, is interesting because it seeks to hold Binance accountable for the financing activities which Hamas used in order to execute its plan. It'll be interesting to see how these cases develop. There's going to be, I'm sure, a several month period of time in which the service of process is effectuated. And then after that, we'll see if anybody, I would be shocked if Binance didn't respond. I would also be equally shocked if Iran did respond. I think Iran's going to default like it customarily does.
So it's meeting to that general awareness and actually knowing about the act itself again.
And that has been alleged, yes.
And so, something that you mentioned as well, war versus terrorism. If we're seeing, counterattacks in a non-war context, do you think that could ever possibly apply either under FSIA or the TVPA?
Yes, if you're seeing terrorist attacks in the non-war context, that is a more easy application of the FSIA's exception.
Yeah, if we have two actors here, possibilities of counterattacks to a terrorist attack. Again, as long as it's non-war, we're dealing with the FSIA, we're dealing with the TVPA.
I think so.
So something else that we kind of touched on a bit at the beginning, but I was just wondering about your opinions on this. Do you think that the U.S. domestic courts is the right forum? I know we've talked about Congress's intent, but seeing as how it's playing out, what the world looks like now, we have the internet, we have Zoom, we're able to, talk across countries, across states. What do you think about the U.S. being the forum here?
I think the United States is absolutely the most appropriate forum for claims that are brought on behalf of U.S. citizens who have been harmed, or U.S. nationals who have been harmed in these terroristic attacks. There is no better place. Our justice system, for all its flaws and faults, and there are many, is one of the best systems of justice for fairness and for due process and rule of law in the world. And the United States not only has a robust system, but more importantly, it has an absolute, inviolable, and abiding interest in being able to provide justice for its citizens and nationals that have been harmed, no matter where they've been harmed, especially in cases of foreign terrorist activity. I think the United States is absolutely the right place. There are other places that may also exercise jurisdiction, but if I was to represent one of these plaintiffs who have been harmed in a foreign terrorist attack, and it was a U.S. national, I would absolutely bring the claim here.
Well, thank you so much for this very interesting conversation today.
Thank you for having me. It's always great to be on the DC Bar, and I look forward to our next chat.
This episode of Brief Encounters was brought to you in part by our sponsor, LawPay. DC Bar members, sign up and we'll waive your monthly fee for 3 months. Learn more at lawpay.com/DCBar.